viewers, welcome back to the Personal Injury Law Show. It's that time of the show where we've got the mailbag. Good evening, Anna.
Good evening, Tony. Good evening, viewers.
What do you think of that ad by WorkSafe?
It really grabs your attention, doesn't it? I think, personally, I'd prefer the free set of steak knives than the prolapse disc, but I think it's a great marketing tool because it makes younger people really think about what you're doing when you take on risks like that in a workplace.
The other part of the ad, John, that I think is more important is, isn't it a message to the supervisors to think?
Exactly, Tony. To basically not direct and put pressure on the worker to do the dangerous duty.
Yeah, make sure that, have a plan. Give them a job that isn't inherently dangerous.
Ideally, that's what we want. However, as we can see, the employers these days, they're under pressure, workers are under pressure, the economy is under pressure, but at the same time, employers, please, the law requires that you take responsibility, that you, the employer, provide a safe workplace and not require the worker and not put them in a dangerous situation.
But the worker's also got to take heed of their own safety, because if they don't, they'll lose contributory negligence.
Exactly.
But look, I want to commend WorkSafe on that ad because I think it's one that people can relate to. So, no, good on you, WorkSafe.
Agreed.
Let's talk about some questions, Anna.
Beautiful. We've got some work cover questions for you tonight, so hopefully we'll have some interesting things to go through. So the first one is from Bob in Baxter. He writes, "Dear PI Show, how long after sustaining an injury do I have to submit a claim? I have an old injury that I thought had resolved and had never made a work cover claim for it. However, it has started to cause me great pain and anguish. My injury was sustained in 2006. Do I still have any rights here?" It's a long time, but
yeah, look,
what do you
Bob,
think, John?
It is a long time. Still make the claim. However, most likely, automatically, it will be rejected, and then you'll be required by the work cover insurer to provide reasons as to why you did not lodge a claim. And if they're plausible and reasonable reasons, Tony, he'll be fine.
But also, if there's contemporaneous doctor's notes of an injury, and also if there's an incident report, or if there's a witness, if there's no report, that will go some ways to assisting.
Exactly. If ideally you've had the work injury, then you've seen either the company doctor or your own GP,
or even a physiotherapist, for argument's sake.
Exactly, and a incident report is written up at the work. Therefore, you've got contemporaneous proof that the injury occurred, then usually, Tony, work cover will accept the claim.
I think so.
Yeah, so again, Bob, make a claim ASAP, because the longer you sit on your rights, the harder it is for you.
I think he should see a lawyer before he puts in a claim, John, because he's already mucked that up, and probably if he gets advice, he can do it properly from now on in.
Exactly. Yeah. Look, workers, viewers out there, the work cover legislation makes it clear the onus is on the worker to lodge the work cover claim. After a short period of time, if you have not lodged a work cover claim, then basically it's a reverse onus.
It is.
You need to show then why you haven't.
Will it matter if Bob's at a different employer now?
No, not at all.
Really. Not at all.
Not at all. So Bob, seek expert advice from a personal injury lawyer to lodge a work cover claim ASAP.
Beautiful. The next one is from Peter in Footscray. "Dear PI Show, I worked in a gym when I sustained a nasty back injury after dragging some gym equipment across the floor to move it for a group class to use the space. The class was starting and I couldn't find others to help. I just had to get it done. Work has not been supportive and said that I should have found some help if I wasn't up to moving the equipment on my own. They have been really patronising and dismissive. What should I do now?"
Well, this is right on.
It's manual handling right there.
This is right on point, isn't it, John?
Exactly, yes.
I mean, I reckon it's absolutely outrageous. He could have, if he was really worried about starting a class, he might have even got one of the people participating in the class to assist him. But
they might have protocol against that, though.
First and foremost, the employer is responsible. There's no doubt about it. So a claim will be accepted, won't it, John?
Yes, exactly. Again, Peter, you need to lodge a work cover claim. I'm not sure if you have. You need to lodge a work cover claim. Again, the employer is not only supposed to provide you with a safe workplace, but to provide you with appropriate and reasonable assistance. Now here, you would have needed assistance to drag this the punching bag across the room, and ideally there should have been someone there to help you. Looks like in this instance there isn't.
And if the employer's patronising and he's suffering from not only physical injuries but psychological, I think go to the GP and get a referral to a psychologist. That will assist you in dealing with those issues, but maybe the psychologist or the doctor could ring the employer and say either back off, or you're going to have someone that's going to have serious problems down the track, not only from a physical point of view, but also psychiatric.
Yeah, it might support him with his injuries too, having someone to talk to.
Exactly. Peter, you're entitled to your medical expenses to be paid, weekly payments, and maybe lump sum
rights down the track.
Exactly.
Okay.
Plus, and don't suffer in silence, Peter, so get the appropriate support around you.
Otherwise, Peter, and we see this all the time, Tony, where people come to us 2-3 years down the track, that we suffered an injury 2-3 years ago, we thought we'd get over it and not really do anything about it, but they're still suffering, and now it makes it very hard, doesn't it, Tony?
Of course it does.
People, workers out there, lodge the claim, get it accepted. Otherwise, it'll make your life harder in the long run.
And I bet you any money, if you do lodge it, you do recover, and if you don't lodge it, something goes wrong, and then you can't pursue anything.
Exactly.
Well, Peter, hopefully you can get onto that with the information we've provided today. The final one is from Raj in Thomastown. Raj writes, I work as a cleaner in a major hospital. I was mopping up some spilled liquid at work and slipped while I was in the process of completing it. I have injured my back and am now really struggling to work as a result. Do I submit a work cover claim on the hospital or my cleaning company managers? Difficult situation. Where do we go here?
Raj, you submit the work cover claim on your employer. It sounds like the cleaning company employs you.
It's contracted to do cleaning.
Yes, to do the cleaning. The hospital is what's called the occupier, so they will be liable in the future. But you need to submit your work cover claim again as soon as possible. See your general practitioner to obtain what's called a certificate of capacity to lodge the work cover claim with your employer, and then go through the process. Then again, you're entitled to weekly payments of compensation if you're unable to work as a result of your injury, medical expenses, and again, lump sum claims should the work injury be severe enough. And in this case, the hospital, Tony, are in the gun, aren't they?
Yeah, I think the employer and the hospital are in the gun. But Anna, you got some advice to the viewers?
Yes. Our viewers, please keep sending us your questions. We really do enjoy receiving them. You can contact us via Facebook, Twitter, or on our website, which is www.thepishow.com.
John, Anna, thank you very much. Viewers, thanks for watching. Stay tuned and stay safe.
Sorry, I was laughing then.